Michael asked me to speak on a couple of issues. First, the Kansas Prompt Pay Act, which is a law in Kansas that requires companies to address your claims in a timely manner when they come in, and also asked me to talk about the process that we use in our department for handling complaints that are filed with us, and to help you understand what we're looking for when someone files a complaint with us and what we will do for you in response to that. The Kansas Healthcare Prompt Pay Act, I'm a lawyer by training, so I put the statute numbers in there for you, for those of you that might be interested. Establishes this overall framework for prompt payment of health insurance claims, and so this applies to all health insurance claims that are filed with companies that do business in our state. And just the general, this is a very short statute, really gets down to the real nitty-gritty basics. But in general, an insurance company has 30 days to pay a clean claim, and that is a defined term in the statute. So they either within that 30 days, they either are to pay the claim or they are to send a notice to the consumer, you the insured, explaining why the payment hasn't been made or why the claim has been denied. And here's the definition of a clean claim. A clean claim is defined as a claim that has no defect or impropriety, including any lack of substantiating documentation, or if it's a claim that required some particular circumstances that required some special handling or treatment for the claim to be processed. And the penalty for companies that do not meet that 30-day requirement of either paying your claim or notifying you of the fact that there's a problem is that the Act requires them to pay interest, which is accrued at 1% per month of the amount that's been billed for the claim. And if within that 30 days, the insurance company can also come back and say, we need additional information from you in order to process that claim, but they have to do it within that first 30-day period. And then you are given, you or your doctor are given the opportunity to submit that additional documentation back to them. The statute suggests that be done within a 30-day period of time. And then after they get that new data back, that new information back, then they have 15 days to now either pay the claim or again, or deny the claim. And I really wanted to make sure, this slide, I really wanted to make sure that people understood, because there is some confusion that happens in our department, and I will tell you, it's frustrating for you as consumers and insureds when you come to our department to file a complaint, and I will tell you, we share your frustration. But there are limitations on the kinds of plans that this law is applicable to. These are fully insured health plans. So these are plans where, if it's through employer coverage, where the employer has actually gone to an insurance company and purchased a fully insured health insurance plan. Also applies to HMOs, the health maintenance organizations. Also applies if you buy an individual, if you go directly to Blue Cross and buy an individual health policy, that is covered as well. There are also some policies that have some types of limited benefits, a hospital surgical policy, and also in dental plans. Now, here's the part that is always causing confusion and frustration for us. The following plans are not included in the Prompt Pay Act: self-insured employer plans. And I want to specifically talk about this one a little bit, because a lot of times, if you work for a really large employer who is self-insured, and what that means is that the employer themselves are actually covering and paying all of the claims, paying for all of the benefits that are provided to you as employees if you work for one of these large self-insured companies. And although you may have, when you sign up for your insurance with that large employer, you may be given a card that has an insurance company's name on the card. What that is that the employer has gone out and contracted with a company to administer those claims for them. So if your employer goes and decides to contract with Coventry, what Coventry will do, you'll have a card and it'll say Coventry. But what is going on there is that all that Coventry is doing is receiving those claims, doing the review of those claims, and then paying out that money. But the money to pay those claims is actually coming from that large self-insured employer and is not actually being paid by Coventry. So those right now, as the law exists, and it's been this way for a long time, those large self-insured employer plans are not subject to the regulation of state regulators like the Kansas Insurance Department. So we have no authority. So what will happen sometimes is someone will come to our department and say, and file a complaint with that, and when we reach out and make contact and start doing a little digging, we find out that it's a self-insured employer plan, and unfortunately we have to come back and tell you this is a self-insured plan, we can't help you, and so that's it. I just would like people to be aware of that. Obviously things like Medicare, Medicare supplement policies, Medicaid, workers' comp, federal employees plans, vision and drug plans, disability income, and then any medical claims that are paid by your auto insurance or your homeowners. If you do not receive that request for additional information from your insurance company or an approval, oh, it just went out. Okay. Oh, there. All right. Okay, if you don't receive, if the claim doesn't get paid or you don't receive that denial or whatever within 30 days, then you have a right to file a written complaint with our department. And as it says on here, you can send a written notice to our department, and I've got a slide at the end that will provide you with some information about how to do that. And once that happens, you will be notified when a consumer assistance representative has been assigned to investigate your claim. And we always tell people, submit your complaint in writing. We will need, when we get complaints, kind of what sets the whole thing in motion is we have something in writing for you, and that sort of is what gives us the permission to start going out and asking a lot of questions on your behalf to the insurance companies. So, and the more information that you submit with your complaint to our department, the better. So the date the insurance company, the claim was sent to the company, the date that the company acknowledged, so maybe they'll send you a form that says, you know, we've received your claim, information about how was the claim submitted to them. And then keep notes of your attempts. You know, have you tried to call the insurance company on your own and checked in with them, and what have you been told when you've tried to check on the status of the complaint? And then, obviously, provide us with copies of any written notices. If you've gotten letters or some kinds of emails or anything else from the companies communicating with you about that claim, if you can provide, if you can provide us with that, that's great too. So what will happen is, if you go ahead, obviously we encourage people right off the bat, make the attempt on your own. Call your insurance company, have all your documentation in front of you, and talk with the customer representative from the company and explain to them what it is that you're concerned about, and ask them to explain what the status of the claim is. And then if you're not satisfied with that explanation, or it doesn't appear that the issue is going to be resolved, that's when you can call us and get moving on the complaint process. And what this happens, and for your information, we get complaints in a lot of different ways. People will at least call initially, and we usually encourage them to write into us. There is a form on our website, on our public website, where you can go in and actually fill out all your information right online and hit the button, and it will come in as an electronic submission, so you don't have to do that. Now, obviously, if you have documentation and things, you'll have to send that in separately, but you can at least get the ball rolling by getting your claim submitted. And when you get when the claim comes in, you will get a letter from us within a very short period of time acknowledging that we've gotten your complaint and that we have started to work it. The next thing that happens is there is a letter that gets sent to the insurance company saying, we've gotten this complaint from Mr. Smith. Please explain to us what's going on with this claim. And the claim, depending on how they respond, we may ask them to do some additional investigation about what's going on with this claim. We may tell them, you need to pay the claim. Or we may have to come back and explain to you, it appears that the insurance company has provided us with a reasonable explanation of why they haven't paid the claim, and we will let you know that as well. And again, this is kind of a repeat of what I said before, providing all of your information, your name, your address, your phone number. If you're willing to be contacted by us by email address is great. providing us with a full explanation of what your case or your situation is, and then obviously all the information about your insurance company. And all the documents, everything that we talked about before. And one thing I did want to mention to you that, and this is kind of a shameless plug, but I always feel like I need to do this. The individuals who work in our Consumer Assistance Division, the consumer reps, most of the ones that are there right now have been there for a very long time, and they're very experienced and very knowledgeable. As I indicated, I'm an attorney by training, and I was actually in the legal division at the insurance department before I became director of the accident and health division. And one of the challenges that we had in the legal division was we would often have to sort of tone down our consumer reps because they're very passionate on behalf of consumers, and so sometimes we would tell them, you guys are trying to practice law as non-lawyers. And so they, I want you to know that when you submit a claim, it is taken very seriously, and our consumer reps go at it from the perspective of trying to resolve whatever the issue that the consumer has. So I want you to know that they really put their efforts into trying to help you to the best of their ability. The other thing I wanted to mention was, and Michael encouraged me to do this, was to mention anything else that I thought might be of interest to you. And Michael, I didn't know if you had talked about federal health care reform at the beginning of your presentation. Assuming that the Federal Affordable Care Act goes forward as it exists right now, one of the things that will happen in 2014 is that there will be a standard set of what is referred to in the law as essential health benefits. And that means that starting in 2014, all insurance plans will have to have all of those essential health benefits included in the plan. This is all plans. And so right now, we don't know what those essential health benefits are. In the federal law, there is a brief list of just kind of general broad categories of what might be in that, what might be included in essential health benefits, but that has not been clearly defined, and we really don't expect to see that until late in the summer or maybe early fall, according to what Health and Human Services is telling us. But that is, I am aware that Autism Speaks has made some testimony to the Institute of Medicine, which is one of the bodies that is looking at this issue, and is going to be making those decisions about what is included in essential health benefits. Autism is not listed in one of those broad categories, but there is reference to mental health and behavioral treatment and those kinds of things. So it's yet to be seen how that'll turn out.